The defense in the Oscar Pistorius murder trial has wrapped up its case. Now, this after hearing the testimony of 16 witnesses. Pistorius maintains that he shot and killed his girlfriend River Steenkamp by mistake on Valentine's Day last year. However, the state contends it was premeditated. After 39 days, the trial will adjourn for a month to allow the legal teams to prepare and submit their closing arguments. The prosecution will submit its heads of arguments by July 30th and the defense by August the 4th. Both sides' closing arguments will be heard in court on the 7th and the 8th of August. Judge Thokozile Masipa ruled against the broadcast or publication of the arguments before the next sitting. And now, for a look at what has transpired so far in the Oscar Pistorius murder trial, we cross live to our reporter Patricia Visagie, who is outside the North Gauteng High Court with Dr. Lewis. Very good afternoon to you, Patricia. What do you have for us today? Patricia, can you hear us? Can you hear us, Patricia? Patricia, please go ahead.
We apologize for those technical problems that we are experiencing. But of course, after today, it has become very clear that the Oscar Pistorius legal marathon is nearing the finishing line in its fifth month. And after 39 court sittings, 24 state witnesses and 16 defense witnesses, of course, South Africa's first ever criminal trial to be broadcast live has now entered its most crucial stage with, of course, the state having to prove beyond a reasonable doubt that the Paralympian intended to kill his model girlfriend River Steenkamp on the morning of Valentine's Day. And, of course, the defense having to prove to the judge, her two assessors, the media and, of course, the world at large that it was a case of mistaken identity. But to unpack some of the legal nitty-gritties, I am now joined by the president of the Law Society of the North, and that is Dr. Llewellyn Lewis. Now, of course, the state's case, if we have to reflect back, they had three major objectives, and one of those three are, proving intent, motive, and of course, creating reasonable doubt. How do you think has the state fared so far?
Well, first of all, remember the onus of proof is always on the state to prove beyond reasonable doubt. Whenever there is the slightest reasonable doubt, that will count in favor of the defense, meaning that they will get the benefit of the doubt, which will ultimately may result in an acquittal. So, first of all, the onus of proof. Second of all, I think the state did a good job at the evidence at their disposal. More or less, besides the element of intent, which is an element of the crime of murder at least, most of the other elements and facts were more or less admitted, not in dispute. That being said, also remember that the state witnesses corroborated each other in all material aspects. Also, from a forensic point of view, the evidence supports the version of the state. That taken into consideration, one must also be very objective and mindful of the fact that the defense relied predominantly on the evidence of Oscar Pistorius himself that came and testified in his own defense. And he also called a couple of expert witnesses in order to secure what he called corroboration of his version. I am concerned to in a certain way with regard to the fact that there was a couple of inconsistencies, improbabilities, contradictions in his version, and obviously they will be mindful to address those issues in argument in writing on or before the 7th of August, obviously.
But although the state performed well, there's still a dark cloud hanging on their case, especially where the police investigations are concerned with allegations of tampering with evidence and not following the right procedures. Now, how can that impact on the state's case now moving into the crucial state of compiling the closing arguments?
You are quite correct. Obviously, it's a heavy burden of proof on the state. In comparison to a civil case, it's much more a heavier onus of proof to comply with, first of all. Second of all, remember, those evidence that you mentioned, the tampering of evidence, or the so-called tampering of evidence, more or less is not in dispute. What is in dispute is the mental state of the accused. And one must be careful not look at other things besides the main issues which must be proven by the state.
Now, talking about the mental state of the accused, 16 defense witnesses who most of them came to testify about exactly that. We saw them buckling under pressure, compromising their credibility. Now, where does that put the defense's case?
Well, it is obviously not supportive of the defense case. And unless you've got corroboration of the version, one can regard Oscar Pistorius' version basically as on its own, standing on its own. And that must be then compared to the state evidence, which is supported to a large extent, at least by forensic evidence as well as expert evidence. None of the experts that testified on behalf of the state actually contradicted themselves. So that evidence must be regarded in high esteem, and I'm sure the court is going to take serious cognizance of that evidence.
Okay. Now, of course, Advocate Barry Roux today closing his case, telling the court that he could not call some of his witnesses as the witnesses refused to come forward and testify, but he had the option to subpoena them. Why did he not go that route?
Of course he did have that option. The Criminal Procedure Act makes provision for exactly that situation, where you can compel a witness to come and testify, where it's in the interest of justice. You can even ask the court's permission that the prosecutor assist you in getting that witness to the court. The court, from their own perspective, may subpoena that witness to court. So I think that was more of a mind game that he wanted to play, and maybe a last effort, so to speak, to create some kind of sympathy from the court.
And a strong warning for the media coming from Judge Thokozile Masipa today, giving a ruling that no information or content from the closing arguments or the heads of argument should be published, broadcast, or in any way put in the public domain, and she will take action should that happen.
Well, obviously it will amount to contempt of court if any of the media journalists out there will transgress that specific instruction by the judge. One will also be careful and mindful of the fact that it might have an impact obviously on the outcome of the case. So one will be hesitant to allow it, and obviously I agree with that sentiment. Let's wait for the court to start on the 7th. Once the court proceedings commences, immediately after that, it will be at the disposal of anybody out there, and then it may be disclosed.
And lastly, our last question, there are some crucial elements that both sides will have to take into consideration now that they are drafting those heads of arguments.
They must obviously refer the court to similar incidents, similar facts in comparison to other court cases. They must refer to legislation, the applicable case law on this matter. So all these things must now come together, basically creating the perfect recipe to put up the cake out there for the court then to eat, basically.
All right, and that, of course, being Dr. Llewellyn Kaluas, giving us his legal expertise on the Oscar Pistorius murder trial today as the defense rests its case. We will be back on the 7th of August when we will be hearing the closing arguments. Of course, a mammoth task await both the sides, the defense and the prosecution, where, of course, they will have to really prove to the judge and the world at large what exactly their cases are. Meanwhile, which is probably even more important, we have been seeing Riva Steenkamp's mother, June, in court throughout the trial, and she has granted several interviews to international media where she told them that, you know, she does forgive the Paralympian, but she feels that her daughter will only rest in peace once the final verdict is heard in this matter.
And that's, of course, SABC reporter Patricia Visagie outside the North Gauteng High Court, where, of course, the adjournment of the court took place earlier on this morning. And the closing arguments will be heard on the 7th and the 8th of August. And, of course, Dr. Llewellyn Kaluas is saying that the evidence of the state throughout the case has supported the state's version.